My name is Jennifer Ching, and I'm actually one of the editors for The Generation. In case, just to give you a better understanding of what The Generation is and what we do, basically we are a student-run online journal under the Burkle Center for International Relations. And what we really try to do is we try to provide a forum online for students, and not only students, but just people all over the world to really, we want to give them a voice to kind of express their opinions and their perspectives on international events, on global issues, and anything like that. So on behalf of the Generation, I'd firstly like to thank Alexandra and Emily for giving us the opportunity to put this panel together. I'd like to thank the panelists for coming and sharing their knowledge with us today. I'd like to thank the Burkle interns for really helping us so much, and especially Lily for really actually organizing this and making everything come together. So I just wanted to share a little bit about how or why we decided to have this panel. So for those of you not very familiar with the whole SOPA and ACTA issue, SOPA stands for the Stop Online Piracy Act. And if any of you were online on January 18th, trying to go on Google or Wikipedia, or even MySpace, Twitter, or Tumblr, I think even Facebook actually, you would have noticed that the website either wasn't working, or there was a blackout sign with a note on it telling you to call your congressperson to protest SOPA. And honestly, as a college student, Wikipedia being down when I was trying to write a paper was just not very helpful. Not that I would ever use Wikipedia for a paper, right? Because students never do that, right? But that really created a very big outroar, and it was probably it was a very big moment in history, in my opinion, because it's the first time companies such as Google and these big websites will actually use their marketing leverage to influence policy. And so after that event happened, we were talking about the whole SOPA issue during our meeting, and what I realized was that I've been seeing a very one-sided perspective of the whole issue, which is probably for most students' perspectives, I'm not completely sure, but it's this perspective that the internet is a wild frontier and it shouldn't be restricted or restrained, and I am a college student, I should watch free movies anyways. But I think during our discussion at our meeting, I've really come to realize that there is definitely another side to the whole SOPA issue, and that is that there are a lot of people in industries, a lot of actors, a lot of artists, that they really depend on their intellectual property to make a living. And so we should address these issues about intellectual property rights and how online piracy can be prevented, right? So that was the whole SOPA issue. And then now we have ACTA. ACTA is basically an international trade agreement among various countries. It has actually already been signed and had passed last year. And basically it is also similar to SOPA in the sense that it tries to act against copyright infringing material by blocking certain elements on the internet, even websites if needs be. The only difference is that this is up to each individual country's jurisdiction. And so it has been passed, but it hasn't really been enforced. And so today that's what we'll be talking about. We'll be talking about SOPA, we'll be talking about ACTA. Did I already say what it stood for? Anti-Counterfeiting Trade Agreement. Yeah. And we'll also be talking about PIPA, which is the Protect IP Act, which is also very similar. And so without further ado, I will hand it over to Reza, who will now introduce the panelists. Thank you.
Thanks, Jennifer. Just to echo Jennifer's sentiments, thank you, Alexandra and Emily, for helping us put this on. Thank you, Lilith, for organizing this great panel that we have before us. And thank you, everybody here in the audience, for coming today. So the first panelist to my left is Noam Dromi. He is a media executive specializing in cross-platform communications programs for corporations, brands, and entertainment companies. He has served as the executive producer and senior vice president of new media for CMP, a film and television advertising agency, where he was responsible for overseeing digital media strategy on behalf of the firm's clients, as well as developing and producing original programming. Noam, if you could just give us a brief overview on your position on SOPA, ACTA, and its impact.
Sure. Well, thank you all so much. It's a pleasure to be here. I think that in the broadest sense, I've been frustrated by the optics around the argument that essentially suggests that it really is as black and white as if you're against legislation, it somehow implies that you're in support of piracy. Now, I think that there is fundamentally no question that piracy of intellectual property, both as it relates to content, but then as it relates to the pharmaceutical industry and other industries, has an impact on a broader economic engine, has an impact on trade and things of that nature. But the reality of it is that I take a strong position that the organizing bodies of the entertainment industry, the MPAA and the RIAA, have made an argument that the protection of intellectual property somehow is of greater importance, both in a literal and figurative sense, than other realities that we face in the world. And my position fundamentally is that legislating this problem and using an increasingly bigger stick to try and address this issue is not going to make the issue go away. I think it was very acutely clear during the SOPA-PIPA debate of the beginning of this year, when a website that I imagine some of you in this room are familiar with called Mega Upload was shut down, that the idea was that as opposed to dealing with infringing content, you could shut down a website without due process, without necessarily taking into account the laws of other countries, and just say, because we believe you've done something wrong, then it's okay for us to do whatever it is we want to do and ride roughshod. So therefore, the biggest, most fundamental concerns about SOPA and PIPA, not so much ACTA, but we'll speak to that as well, ultimately came to pass. And the example that I use is that I find that to be consistent with the argument that says you're in New York, you're walking down 8th Street, and you see somebody selling, they've got a blanket laid out and they're selling illegal DVDs of the latest Hollywood movies. And the argument is that instead of dealing with that particular individual and the enforcement and legal mechanisms to ensure that they prevent from doing that, the answer is, well, let's shut down the whole street. That seems short-sighted. Ultimately, that is not addressing the problem. And I also feel like the lobbyists of these particular groups are there is a problem, but I believe that they're wildly exaggerating the scope of the problem, and that's not going to help. It also is going to stifle innovation and business models, and I think that if you look at Netflix streaming, I think if you look at what iTunes has done, what some of these newer business models in the digital realm have done, there is an opportunity where innovation, legislative mechanisms, and enforcement can all peacefully coexist without pretending like the trade organizations of this industry have the right to dictate policy where I believe they do not. Thank you.
Thank you, Noam. To his left is Professor John Richardson, Jr. He has served the UCLA community for more than 30 years as a professor of information studies and has guided dozens of graduate students into print. At the moment, Dr. Richardson's teaching interests revolve around Facebook in the context of ecological informatics. He's completing a certificate in field ecology at UCR. Dr. Richardson's VLX course on Google explores the rise of the internet and the World Wide Web as an important, if not authoritative, source of information. Furthermore, it highlights significant social issues such as anonymity, cultural hegemony, self-identity, personas, self-respect, community building, copyright, and fair use, and privacy rights. Professor Richardson, if you could please do the same thing that Noam did.
Well, I feel like if we're here for a piracy convention, we all ought to be issued hats at the door. And
eye patches, too.
Exactly. Well, clearly something's afoot. I think what's absolutely fascinating when it comes to intellectual property is that we've had this concept of copyright for roughly 200 years, and we've pretty much been able to ignore it. And yet, look at this audience this evening. Look at you. Why are you here? Why did you turn out? Something's really afoot. Something's really different, and our behaviors are changing, and now it appears that we can't ignore copyright. So I'm interested to talk about a bit of process. This is sort of like Schoolhouse Rock, remember? Unless you're 14 and just graduated from UCLA, somehow you skipped over I would call it junior high, middle school, or high school, I want to talk a little bit more about PIPA because it's easier to talk about SOPA. And what are the realities? So I'll share with you some of the vested interest in all of this. But I guess ultimately, yeah, if I want to talk about my bona fides, I was a dean in graduate division for 5 years. I'm not in favor of piracy. If I have this, anybody have a CD, by the way? Nobody has CDs, right? There's an example in January where digital downloads outsold the physical media for the first time. But this is purely a teaching example. I got it in Eritrea from a Syrian vendor. I'm pretty sure it's pirated. I revoked the first doctoral dissertation when I was a dean. Why? For wholesale plagiarism. So, yeah, is it taking a hammer to a flea? What is the problem? So I'm looking forward to hearing my colleagues and your perspectives as well, wrestling with something needs to change. Our behaviors have changed. How do we think about it? So I'd love to explore those issues with you.
Thank you, John. Nat Segaloff is a journalist for Boston Herald, CBS Radio, turned college teacher, Boston College, Boston University, turned author, written 11 books, turned producer at A&E, TLC, USA, Sci-Fi, HBO, with a background in motion picture marketing and publicity, Paramount, Disney, Columbia, Fox, United Artists, MGM, etc. His varied writings include works on filmmakers William Friedkin, Arthur Penn, Sterling Siliphant, Wallen Green, Paul Mazursky, and John Milius, and he has produced biography TV shows on John Belushi, Larry King, Stan Lee, Daryl F. Zanuck, and Sherry Lewis, and Lamb Chop.
Thank you. And if there's one extra job after Jennifer, I'm looking for a show.
Nat, if you could just give us a brief overview of how you feel about SOPA and its impact.
I'm really two people today. One is I'm on the board of directors of the American Civil Liberties Union of Southern California, which is, the ACLU nationally is the nation's largest litigating organization for civil liberties. Our client, as we like to say, is the Bill of Rights. I'm not a lawyer, as you have gathered from that introduction, although I actually have had friends who played them on TV. But I am also a person who's had his stuff ripped off. And so I'm kind of aware of the breadth of this issue. The ACLU's policy on SOPA, as it is for all intellectual property, is that we want to preserve the rights of the people who create and own the intellectual property. And we do believe that SOPA is a bit broad-brushed. It's like chemotherapy, if you will. You may kill the cancer, but you'll also kill the patient if you're not careful. And we're very protective of the First Amendment, as is, believe it or not, the U.S. Supreme Court. And we think that for this stage, and we've testified to limit SOPA, we hope it will have some effect as it moves through our society and becomes implemented. The other part of me, as the filmmaker part, is for those of you who have handheld devices right now, you may want to check YouTube for something called Steal This Disc, and it may be indicative of what we're talking about. It's a 2-minute video which went viral a while ago about a young filmmaker who's selling pirated videos in an alleyway. They're of his film because he made such a bad deal with his Hollywood distributor that the only way he's going to make any money on the movie is by selling pirated copies. The point being that there's just as much piracy from a filmmaker's point of view going on in the film companies who are trying to outlaw downloads as there is in the people in the dorm rooms downloading movies. That's going to be encapsulated. As an ACLU representative, I must tell you that I cannot give you legal advice. Call your own lawyer if you have any legal questions, but I can try to articulate the ACLU's policies, and we'll be doing that from this point on.
Thank you very much. Danielle Van Leer is Senior Counsel, Intellectual Property, and Contracts Lawyer at the Screen Actors Guild, American Federation of Television and Radio Artists. She began her position at the former SAG in 2000 and is now responsible for managing SAG-AFTRA's third-party contracts and intellectual property, as well as other efforts aimed at protecting the rights of SAG, AFTRA, and its members. Danielle, if you could just do the same that everybody else has done.
Well, I am a lawyer. I haven't played one on TV, but I know plenty of people who have, including many on our board. I do want to note up front that the views I express are not necessarily intended to represent SAG-AFTRA's views. I was not directly involved with our advocacy or involvement with SOPA or any of the legislation. Although I am IP counsel, it's we also have a very involved legislative team that works on that, and they were the ones that were formulating our policies. So my views are mostly my own, although they often will coincide with SAG-AFTRA's views. So I just need to caveat that up front. And I generally speaking, I think there's interesting opinions that I've heard expressed by my colleagues up here. Like I said, I wasn't directly involved with SOPA, and for all intents and purposes, SOPA, as it stands, is dead in the form it was in. And I think we've already seen the two big sides in the debate, which people ask, who are the two sides in this debate? It's really more than two sides. I mean, I think the public face on this, this argument was made out to be, the big bad entertainment industry versus the poor little people who can't afford to see movies. I think that was the face that got put on it, or free speech. So I guess I want to ask, how many of you think it's okay to walk out into a store and walk out with a CD or DVD you haven't paid for? How many of you have downloaded before or know somebody who has? I mean, I certainly know plenty of friends who have foolishly admitted to me that they've done it, many of whom are overseas. I mean, I have a number of friends in Sweden, and downloading is a way of life there. One of my friends stopped downloading after I kind of had a heart-to-heart with her, and her friends are like, are you crazy? Why? Big bad American movie industry, we're like Robin Hood, we can take from them, It really is a Robin Hood mentality. And, to me, I think, part of it is in how the debate has been formed. I mean, this word piracy has come to be very glamorous thanks to Johnny Depp and Disney and, swashbuckler movies. I mean, frankly, I prefer to call it what it is, which is online theft. I mean, it's theft of intellectual property, no matter which way you look at it. It's illegally obtained copyrighted works. Even technically speaking, the gentleman who was selling his own movies, in the back alleys, he entered into a contract. He's breaching the contract with the studio. I agree that there are some serious problems sometimes with small filmmakers, getting screwed by distributors, whether it's the independent distributors. I have plenty of friends who have definitely entered into their share of bad deals for movie distribution. But, the perspective that I want to bring to this, and that debate I've had with a lot of my friends, is that, again, the debate has been formulated as, the movie industry, the big bad Disney, Warner Brothers, all these big companies versus the little guy. But really, content theft hurts the little guy. It hurts, the actors who rely on downstream revenues. The percentage of a working actor who, the percentage of the revenue that comes from downstream revenues, which would be DVDs, licensing it to TV or home video, the iTunes downloads, Netflix, the legal content. Most of their income doesn't come from the work they do up front. It comes from, the reliance on those downstream revenue in the form of residuals or for musicians' royalties. So it takes money literally directly out of the pocket of those working actors and artists and employees in the industry, and it also tends to have a trickle-down effect to ancillary industries as well. I mean, there's when you think about whether movies might be produced with bigger budgets because they think that there's a chance to make more money. Maybe they're going to use, when they think that their content's going to be pirated, maybe they're going to hedge their bets and not create as big budget of a movie, which means they're not going to hire as many people, which means there's less money going into the economy. I mean, so it's really a middle class argument. I mean, it's not big business versus the little guy. It's the middle class that's being affected, and there's a lot of other issues affecting the middle class as it is. So I think we just need to reform the debate around this issue and focus less on the big guys that are being hurt and look at who is really hurt behind the scenes.
Thank you very much, Danielle. I was going to ask the question of all 4 panelists, generic, but I saw Noam shaking his head during Danielle's brief overview. So Noam, what were you shaking your head at, and
Sure.
why?
I want to begin by important qualifications, which is I'm not an attorney. I am a content creator. I wrote a film that came out last year called Dolphin Tale. I also happen to be, in the guise of my work at Social Type, as well as the consulting work I do as a digital strategist on behalf of networks and studios, someone who directly is dealing with working in collaboration with the anti-piracy groups at those organizations by which I am employed. But I respect and understand Danielle's position. Here is why I am challenged with some of the claims and feel that to a large extent it oversimplifies the conversation, specifically as follows. Most people I know don't treat it as the big bad content industry versus the little guy. They treat it as the fact that the big bad content industry wants to implement legislative fixes that fall right in the face of due process, that essentially can just infer that someone has done something illegally and thereby shut down a site. They can make claims that provisions that exist within U.S. copyright, which include fair use, which include parody, are somehow not acceptable, and find creative workarounds to essentially imply that those things are being done illegally. And look, the reality in my mind is simple. I think it's fundamentally unfair for the entertainment industry when they are faced with pushback to the manner in which they are trying to address this issue to say, oh, therefore you support piracy. My position simply remains as follows. Piracy is a problem. There need to be some enforcement mechanisms to address it, but the legislative fixes that are being proposed are disingenuous. I think in some ways they overstate the extent of the problem. And there's always that argument that says, depending on your point of view, you can find the facts to suit that argument. And I would respectfully submit that the claims of economic, what's the word I'm looking for, effect on the middle class in this industry at a time when entertainment companies are posting record profits are simply not true. They're a convenient way to speak to an argument, and I have a series of data points that I could speak to that say that the extent to which they are saying there is a problem that is being affected, it's just a way for them to ultimately control emerging business models. They don't like, we talk about living in a free market society where the market should dictate the terms of things. Yet Steve Jobs and Apple did something amazing with iTunes, but then all of a sudden it's a problem because, we're now being limited into one particular way, and there's been a level set in the marketplace, so we can't charge $1.39 for individual downloads. I'm not dismissing the import of the problem. I take issue with the methodology that is being proposed to fix it at this time.
All right, and I think a follow-up question to that for you, Noam, is what should be used to fix the problem at this time? And this can be given to all of our panelists after Noam answers.
I think courts. I think at the end of the day, if you walk, to Danielle's point, if you walk into a store and you steal something, there's a particular mechanism for the store to either have you arrested or find a way to address the economic harm that was done to them. I think by the same token, there ought to be measures in the law. I qualify again, I'm not an attorney. I'm speaking broadly about my same understanding. And Reza, just to take a step back, one thing that I made an effort to do so that I'm not speaking in the abstract about bits of misinformation that I think so many of us are ultimately faced with in terms of trying to understand these laws. In addition to the ACLU, one of the greatest organizations that is trying to protect our interests is the and I totally just had a blanking moment. The Electronic Frontier Foundation. Thank you. Go read these laws. Don't think about them in the abstract. Go understand what they actually say, and realize that even when it comes to ACTA, it isn't what is or isn't there, it's the vagaries of the law that, in my mind, present some fundamental problems. But Reza, just quickly to answer your point, there have to be enforcement mechanisms, there have to be due process, and this idea that the responsibility has to fall on the websites, that we're going to codify into law certain language that require them to address enforcement and address technological fixes, that can exist to a point. But, using my film Dolphin Tale and Warner Brothers as an example, Warner Brothers has a anti-piracy group that is responsible for going out there, finding where there's infringing uses, asking the sites to take them down, and if the sites refuse, legally insisting that they take them down. Not writing laws that says, you're an infringing website, we're going to shut your website down, because in my mind, that's absolutely ludicrous.
John, what do you feel? Do you agree with Noam that courts should be the answer to the piracy problem, or?
Well, there are a couple of things I'd love to say I agree with, because if you haven't read the law, you really need to read it. And yes, I agree with Danielle, it's dead now. But remember, there were two bills, they're companion bills that are introduced, and you really ought to read the details. Absolutely the point about due process. So if I understand the bills that were proposed, the Justice Department could make a blacklist. And then you're asking, and so I find my domain, and I have a personal one, on the blacklist. And how do I do anything about that? It's really interesting, though, if you read some of the other stuff about, the devil's in the details, if you want to. So what about service providers? So a service provider shall take technically feasible and reasonable measures designed to prevent access by its subscribers located within the U.S. to the foreign infringing site. Okay. I'm sorry, isn't that kind of like asking a plumber to fix it so I get Perrier out of the tap? Or if you don't care for that, look at what the internet search engines are going to have to do. A provider of an internet search engine shall take technically feasible and reasonable measures as expeditiously as possible, but in any case within 5 days. I don't know. It's back to is it the means? That's what I think you were saying about the methodology. You've got to have some reasonable end. So back to the court. American jurisprudence is fabulous. It's just got one big problem here. It only applies to the United States.
Okay. Nat, same question to you.
Well, without talking about the efficacy of piracy, there are a couple of things that the ACLU has been concerned about, particularly as it involves the First Amendment. The mere existence of infringing content online does not justify the removal of non-infringing content, especially where they may be bundled. The example we give is if you've made a hyperlink on your web page to another web page which all of a sudden posts something which somebody somewhere who owns content thinks should not be there, then you get your web page shut down. And by the way, they don't have to send you a letter. They don't have to even call you. They can take out a small legal notice somewhere, and you have to be responsible for reading their minds and finding it. So the due process is already being eliminated. If you're being evicted from your apartment, they have to send you a letter. And it's deemed as deliverable if it's even under your door. But if you've infringed on somebody's copyright, all they have to do is, if anybody saw Animal House, put you on double secret probation. And nobody can read minds because that's as much as they have to do. I have to use a special effect called glasses. See the rest of this. So what we're saying is, previous acts that did not pass, previous mindsets, which is what SOPA really comes from, living or dead, the ghost persists, have to more narrowly define the term a site dedicated to infringing activity. Anything can be a site dedicated to infringing activity if somebody somewhere complains about it. Whether it's the Play Solid Gold Cadillac or anybody walking out the street can stop General Motors if they complain. That shouldn't be what happens. And if anybody here has ever tried to get a webmaster to respond by sending him or her an email, or has ever tried to call Google on the phone, I think you know how difficult it is sometimes even to protect your own rights. there's the mindset in SOPA and other proposed legislation that may come up that says the Attorney General may bring action against any website, domain, or other entity, and I'm using generalized language, illegally provides content or enables illegally provided content. The language is so broad that anything from meta search engine to, well, we had this case a few years ago. Remember, some kid used his grandmother's computer to download some songs, and the RIAA under Hillary Rosen went after the grandmother. And the name's familiar. The definition of what constitutes providing notice, as I mentioned. And the other part of it, which really bothers us in the privacy interest business, is in culling information that would identify service providers and people who might be infringers, there is a very large potential for the invasion of privacy, for compiling data about you, the website you visited, and your history of browsing. That may not be anybody's business and may not at all be germane to the question of whether you have or haven't downloaded anything that you shouldn't have. So it's the process itself which is bothering the ACLU in terms of possible First Amendment infringements. The question of piracy itself, I think, is pretty much settled. If you own stuff, you don't want it to be stolen. We're not talking about that from our point of view. We're talking about the process of infringing on the First Amendment in trying to stop infringement on intellectual property.
Thank you very much. Danielle, I know you have lots of responses, so I'm just going to let you get to it.
Yeah. Well, so, I agree in principle with some of what's being said, but I disagree with the practical implications that, related to the bill. First of all, the bills were specifically aimed at foreign websites, not domestic sites. Noam mentioned, the courts are the way to approach this, and that I do agree with. There was a response bill proposed in response to SOPA called the Open Act that would have put the enforcement mechanism within the International Trade Commission, I believe is an executive agency. Courts are the best place to adjudicate these kind of disputes. Courts have been handling intellectual property disputes since the advent of our country, basically. Copyright, like the First Amendment, is embodied within our Constitution. So we're not talking about some recently created right. And I will say it's been a little while since I actually read the text of the legislation, all 78 pages of it. But I did read every word of it at the time. And, that's one thing where I do agree with Noam, is that it's important to get all sides. I don't think the EFF is the only place you should be looking to, because they have a very specific mindset on these kind of bills. I do think you should look at both sides of the story, because as with anything, has anybody read or seen the movie Rashomon? Which was, it was basically a murder is committed, and it's told from, is it 2 or 3 sides of the story from different perspectives of witnesses, the truth being somewhere in the middle. So, whether the side that proposed SOPA is correct or whether the EFF side is correct, the truth always is going to lie somewhere in the middle, and the right approach is probably somewhere in the middle. But the bill did include procedural safeguards. It's not like, you could just go and say that site has one piece of infringing content, shut it down. It was for sites, and yes, it's vague wording, but primarily, I forget the exact wording, but primarily directed at the U.S., and primarily intended to infringe content. I had the words here a second ago. But it was primarily dedicated to the sale of content, illegal content. But have any of you ever, without saying whether you've downloaded or not, gone to one of these so-called rogue websites? During the SAG Awards, part of my job at now SAG-AFTRA, part of my job is to enforce our copyright in the SAG Awards. And that includes going to YouTube and sending the takedown notices, because immediately after the show, clips of the show go up. What was interesting this year is even before the show went online, there were already clips up on YouTube. And all these clips were, it would say in the title, forget what year this was, if it was the 18th Annual Screen Actors Guild Awards, it would say something like that in the title. And then it would be a 2 or 3 or even longer minute clip that says go to blah 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 site for live stream of the SAG Awards, which we were live streaming online and had through on 2 different TV networks and had through, foreign affiliates all over the country. But even before the show was up, there were already these websites saying, watch the SAG Awards here. And then when you go to those websites, they look almost the same as going to a legitimate site. There's Google ads on the side of it, so they're getting ads served by Google, making money off of the click-throughs on those. Google's making money for ad serving. You type these things into Google, and Google is getting money for sites using AdWords. So part of what this legislation aimed to do was to try to cut off some of those revenue sources, so that one, Google's not profiting from, this infringing content, and these sites are not being able to make money through seemingly legitimate sources. It was part of what it did was to cut off credit card processing and their ability to charge, to use credit card processing services for subscriptions to sites that were for services for infringing content. So, it wasn't intended, this was not intended to take down sites where people posted pictures of their pictures of their baby dancing to Prince. Videos of their baby dancing to Prince. It's not to shut down YouTube, it's not to shut down Facebook, it's not going to shut down Flickr. There were due process mechanisms installed into the bill. Was it perfect? No. I think the bill had its issues, but something needs to be done legislatively, because it's all well and good to go to the courts to try to stop these people, as Noam suggested, but there's no jurisdiction over these foreign defendants. Not only are the people running the sites or the servers based in foreign countries, they're using false registration information. And I've seen plenty of examples where all the information on when you do a who is report, it'll say something's in Hong Kong and something else is in Malaysia and something else is somewhere else. And then when you start digging deeper into those registrations, they don't exist. So you can't even get to the people. So the only way to do it's essentially cutting off their access. Think about an animal, you got a monkey stealing apples from a tree. What do? You build the fence a little higher so they can't get to it. And that's kind of what it was aiming to do, was to block that access to those apples in the form of revenue.
Oh, John, you obviously want to say
Yeah,
something?
don't get lost in this. Let me just read the section that defines what foreign is. And remember the point I made that American jurisprudence has a major problem. It only applies to the United States. So here's the definition. Quote, definition. For purposes of this section, a foreign internet site or portion thereof is a foreign infringing site, still with me? If the internet site or portion thereof is a U.S. directed site and is used by users in the United States. That doesn't sound very foreign, does it? So what I think we're getting at here is that we can't do anything. Well, you mentioned, I believe, mega uploads. So the United States was successful in prosecuting. Now, the site's down, but if you've heard the latest, I guess, a couple of hours ago, they don't think that there's going to ever be a case that goes to court. What does that text mean? What did you hear when I read it? The short answer is we don't know until it does become a law, and then we have some sort of a case, and then some court gets to interpret it for us. But I think you're reasonable individuals, so you can hear what that says. But I see a problem with it. And I don't know. Shall we make Daniel the bad guy here? Let me, just in getting ready for this, there was some interesting stuff. Why is this so important? It is the media. So let me ask you about, how many of you are going to the movies? My goodness. What's wrong with you? Last year, movie attendance was down again 4.4%. It is now at the bottom since, I guess, the lowest since 1995. Anybody buying a CD, a music CD? Wow, how retro. You all know what the problem is. I think I mentioned in January of 2012, digital downloads exceeded the physical purchases of these things. And I'm not encouraging you to go to Santee Alley And my favorite example is going down there, because you didn't say I'm a sociologist by background, so I love to study this sort of behavior. The guy's there with his gym bag and he's got his CDs, and I'm just watching how his business is going. And I couldn't resist. I went up to him and I said to him, "How many times have you been arrested?" And he freaks and he goes, "Please, this is the first time. I've never sold this stuff before."
Never did this.
Yeah, and I'm going, "Hey, I'm not undercover. Relax. I just am curious." And he's headed off down the street. How many of you are watching network television? I have to say personally, I love NCIS. But I'm not the right demographic. And if you look at the latest statistics on network television, viewership is down across the board. Okay, and now this gets close to home. What about publishing? How many of you are buying ebooks? I see how many. Look at how many of you've got computers already here. A netbook, an iPad. Yeah. So 2 years ago, I had a visiting scholar from Pakistan, and I was asking him about his book budget. And he said, "Oh, I don't buy books anymore." I go, "You don't?" So what do you do? He said, library.new. Anybody? Have you ever gone there? I instantly went there. It's one of those linking sites. And so their companion site, I love the name of the companion site, is iFileIt.it. Kind of looks like it's coming out of Italy. Yeah, your point about, where can you find them even? I've written 12 books. And so as soon as I look at library.nu, it is amazing. Approximately 400,000 to maybe 1 million wonderful scans. And there are readily available. Now, I have to say my livelihood doesn't depend on writing those 12 books. I'm paid by the University of California, so if I didn't write them, maybe I wouldn't get promoted. So I guess all I'm trying to say, hey, I'm an author too, and I don't want to get ripped off. But I was just amazed. In March, library.nu is gone. So I guess what I'm trying to make the point at, it is the media. These are people's livelihoods, but your behavior is changed. You're not going to the movies, you're not watching television, you're not buying music videos. If you are, Apple's getting a good cut of it. So what are you doing?
Danielle wanted to say something.
And I think he makes a really interesting point about the behavior changing. And again, this is a conversation I've had with my friends in Sweden, where how have they started to address some of the downloading issues and some of what we've done. They created, how many use Spotify? That came out of Europe, and you pay a small subscription fee for the premium use, and I believe if you want to use it on your mobile, you have to pay a small subscription fee. And my friend told me even before we had our heart-to-heart about downloading, she stopped downloading music as soon as Spotify became available. So I think a lot of it is changing a need to change behaviors, and the industry needing to learn how to compete with free. And I had a similar experience as far as having my work copied, and I think this is really indicative of a change in culture. I teach sports and entertainment law. My entertainment law class, given my background, is very intellectual property heavy. A lot of copyright, and the whole is anybody familiar with the concept of idea versus expression in copyright law? So it's in copyright law, you can copyright, you can protect the expression of an idea, but you can't protect the idea itself. You can't. That's why like a biography, the actual book itself is protected, but somebody else could go and write essentially the same story or the movie or whatever, and it's not going to be copyright infringing. So I went into a long discussion. We spent several days dealing with copyright issues in my class. For my last class of the semester, I always do a really, really long review PowerPoint that basically goes over the entire semester's worth of discussion in preparation for the exam. Well, somehow, I think just out of curiosity, I was doing a Google search on myself just to see where I was popping up. and this website, Outline Depot, pops up. And I see, oh, one of my students put up an outline for my class. Let's see what's there. This is after probably half a semester talking about copyright. My student had essentially just taken the PowerPoint, which I had posted in PowerPoint form, turned it into outline form, and turned it into this outline website where they get credit to download other outlines. Basically, for every one you upload, you can download one. And I was like, wait a second, that's my PowerPoint there. And, it was my expression of my PowerPoint, not just fact-based. So it was a blatant copyright infringement and probably it was a blatant violation of the honor code at the school. So I approached this website and said, hey, you've got infringing content up there. This is my PowerPoint. I can prove it. Help me find out who did it. They're in violation of school policies and they're violating my rights. The website basically was like, F you. We took it down. Left me, no recourse. I said, well, fine, I'll file a subpoena. We don't know who did it. Once it's up there, we don't know. We don't know who did it. Just completely stonewalled me. In this case, it was an outline. It's really, aside from my personal, annoyance at it and my feeling of being violated, no harm done. I wasn't going to spend hours and hours chasing after the site. I wasn't going to spend money to litigate it. But that's what happens with a lot of these sites is, you get this big FU. But I think the fact that somebody in a law school class, after spending half a semester learning about copyright, didn't think twice about doing this is indicative of something that's changing in our society as far as that stuff goes. And I think there's something that needs to change back.
It would be nice if we could have a surgical approach to enforcing these problems instead of the broad brush. Harlan Ellison, who is a very prolific writer of scripts, fantasy, speculative fiction, he wrote A Boy and His Dog and had the ideas on which Terminator was based. And in fact, there was a legal settlement because of some infringement. Spent well into six figures a couple of years ago against AOL because people had been posting his stories online and he had never authorized that. And he had to ask for contributions from fans and from the public because he couldn't afford to keep the lawsuit going against AOL. Here's one guy who didn't want his stuff posted. The settlement was that AOL or any other server now has a certain number of days to take down material once they're notified of an infringement. But again, as I said before, try getting to them. Try finding whom you can call, or try filling out all the forms online to show that you're the copyright owner and not some person who posted it. So there has to be a little bit more coordination between the people who are guardians, if you will, who are in jeopardy, and the people who are actually doing this illegal posting. By the way, sitting next to you reminds me, I'm an AFTRA member. I have to send in my dues. Thank you.
Nat, I think part of the point of consideration, though, again, around the optics of this conversation, there's a lot of emotion. Mm-hmm. I maintain, again, that it is not as black and white as Robin Hood, the big, bad corporation versus the little guy who just, who can't afford to just pay the ticket to go see a movie. I mean, some honest evaluation of circumstances. A lot of the piracy of specifically films, focused on that segment, happens from people in and around the business of entertainment themselves. It's not the question of someone with the camcorder going and filming and putting up a crappy copy of the film, but it's film labs, it's people who get screeners. So it's ironic to me that an industry whose members and whose participating individuals are responsible or kind of the patient zero of the problem are now seeking a way to legislate that. Create an informational campaign. Here's the thing, and I think what I appreciated about Danielle's point, and in general, what this new thinking does is afford us the opportunity to understand is there are changing values and changing social mores around these issues. There are opportunities for new and emerging business models that legitimize it. Now, the reality of it is, as someone who can admit here that once upon a time I was an infringer, the reality of it is that iTunes, which is now a number of years old, made it so easy and afforded such a level of security, because the other thing that I think people forget about the piracy discussion is you don't know when you're going to some site what you're getting, whether it's turning your computer into like a zombie that is essentially part of a dark net that now is being used for other nefarious purposes, and when these businesses found more efficient and economic ways to make their content available to you, whether it was on this device, whether it was on your phone, whether it was on your set-top box, it fundamentally changed how all of that worked. Perceived value is what ultimately matters. And what I would maintain to all of you, there's a really cool new business that I was just recently exposed to. It's called Tugg, T-U-G-G. And here's the essential value proposition. If you live in a small town and you want to see a film that's maybe more of an art house film that will never be at your local theater, there's a crowdsourced way by which you can say, if enough of your friends basically sign up and say, we want to see this, the theater has an agreement with the distributor to make it available. It affords us the opportunity for innovation. I maintain again, everyone in this room, the best reason not to engage in piracy is because you don't know what you're getting, and there are other ways for you to get what you want. What I continue to be frustrated by, because I believe it is fundamentally disingenuous, is this attitude that just basically says, from the content providers, not the middle class person, but the organizations, the multinational corporations that control this content, that say, we're going to give it to you on our terms, we're going to make your satellite and the cable carriage and all these other things increasingly more expensive, increasingly out of reach, narrowing your field of choice, which falls in the way of antitrust, but that's neither here nor there, and you're going to like it. And people are saying, no, I'm not going to like it. Find a way to create business models that support what it is I'm doing, and we'll be able to play fair. We've got a lot of work to do. The reality of it is I accept the premise that says, on the one hand, as Danielle pointed out, that courts don't have international jurisdiction. I think also this notion that American copyright reigns supreme over the world. In some countries that have different interpretations of a copyright, I have fundamental problems with that as well. But all I'm saying is that the big problem, which I think everyone on this panel ultimately has some level of agreement in, is the vagaries of the language. As Nat pointed out, it's that surgical solution. If we could address those issues individually, that's fine. But language that is unduly vague, that basically SOPA as originally written, or even ACTA as originally written, made WikiLeaks illegal, made other things illegal, which frankly are an essential part of our ability in an information age to live and have transparency, have democracy, have open markets, open export opportunities, to really allow our values to be a part of the global conversation. And I'm not saying there isn't some type of legislation at some point that might do that, but the legislation that's put forth, and as was pointed out at the very beginning, ACTA is already law. I don't remember any conversation with stakeholders about it, and fortunately, its original framing was diluted because a lot of people said in some ways it was actually worse than what SOPA was doing. All I'm asking us all to do, which I believe everyone on this esteemed panel is as well, is be informed and be a part of the conversation to find solutions, not assume that laws will fix the problem.
Now, just to latch onto a point that I think all four of you have mentioned before, things are changing, and there are many sides, as Danielle said, to this argument, and one of those sides is changing very, very rapidly. And that side is the audience for the films that's consuming. How do industries, how do organizations like Facebook and Google, why did they crop up and start defending this audience? And why are other organizations saying, no, we want SOPA? And is the solution to that something like Tugg? Or is there some other solution that we haven't found out yet? Whoever wants to go first.
Well, I'll say asking why these organizations jumped up. They were jumping up to protect profits. I mean, plain and simple. Google did not put the message up there because it was concerned with your free speech. Google put the message up there because it was concerned with its profit.
I just feel like that's cynical in some ways. I don't feel like it's that black and white.
And I don't think, maybe I'm stating it more black and white than it is, because I don't think it is. I agree it is not that black and white, but Google so far this year has already spent $5 million in lobbying because of this legislation, which is way more than the entertainment industry has spent, and it's like 240 times what it spent this time last year. Google's not lobbying with that kind of revenue, that kind of money to protect free speech. I've been involved in legislative battles on other fronts with Google and internet service providers where they've pretty much, in a completely unrelated, for right of publicity legislation, they came in and said, we need carve-outs for this to protect our AdWords. So they made it very clear they were protecting not free speech, but their bottom line with advertising. I've had that conversation with their attorneys and lobbyists. Other organizations, I absolutely believe, the ACLU, EFF, all those groups, were out there to protect free speech. But when you're talking about the big players, I think Wikipedia was in an interesting position somewhere in the middle of protecting its business model as well as standing up for speech. But I really do think the reason a lot of these groups came out so strongly against this legislation was all about their bottom line.
I think the perfect person to respond to that is John, who teaches a class on Google.
Yeah, I've been thinking about it. I need some help. Anybody from computer science here?
I'm sure.
Well, what I want is somebody to address the algorithmic solution of it. It's a business model. I can see how you can just be crass and say it's just about money. But if I'm a computer scientist, I've got a problem. I've got to write it algorithmically. So how do I write code that can flag those sites? I'd rather not... maybe if you just give me the list of domain names from the Justice Department, I'm going to be real pragmatic and say, how do I solve it as a computer scientist? I've got to write an algorithm. So that's one answer to the puzzle, is how much work is it going to be for me?
But they already do it with like child pornography, for instance.
It's a lead pipe cinch. You're talking about a 10-minute operation.
There are some people who simply can't figure out how to open certain files. Most of them are over 12 years old, perhaps. But, there's encryption. That will work some. Each level you put on a protection is going to diminish the number of people who can illegally access. But it's not going to eliminate that any more than prohibition eliminated drinking back in the 20s and 30s.
And there will always be a viable black market. John, I would submit to you that maybe if we think about it as sociologists, that is really where the rubber meets the road,
Yeah.
because ultimately, I think the point that you've all made, which I fundamentally agree with, is the fact that there is a clear tipping point in which our relationship to both actual goods and virtual goods has changed. And there's a lot of qualifying, a lot of this notion that says, well, it's not the same thing, and you don't understand in the same way the economic harm. All I mean to say is these new businesses that make you a part of the engagement in the relationship, that incentivize your legal use of the product, are frankly where we're headed.
And that's why I want to engage the audience with this, because the point I was trying to make is that if you're not going to the movies, if you're not getting music as much as you used to, you're not watching network television, what are you doing? So your behavior is changing. My guess is your eyeballs are on your computer, your device, and so let me give you an example. Yeah, I've had the same thing where there's a harvester that goes out, and I used to post my PowerPoint lectures behind. Now I put them behind the screen because I think it's only fair because you guys paid for them. The world didn't, so then why bother coming to class anyway? But let me ask you this question. What do you think of the fact that she's got an outline up there? Do you think about... I'm sorry, I didn't know her before today. Now, if I see her PowerPoint up there, I sit there and go, wow, look at this logical, organized approach. Look at the way she thinks about things. I don't know. I mean, is there a different opinion or attitude that you have towards her because her work is out there? As an academic, again, you know my bias. I'm not... If I don't publish, well, I'm tenured, so... deal with it. But you know where I'm going with that. I'm trying to argue that...
Get rid of tenure.
Yeah, let's get rid of tenure.
Yeah.
Well, yeah, exactly. That's an interesting point that I can make some sort of judgments about this person who, otherwise I'd have to go to her class. Now maybe I do want to talk to her. I am in the industry. I like the way she thinks. But if it wasn't up there, so I think our attitudes are changing about how we think about these things. And are our laws trying to catch up with it?
No,
Except you went ahead
before we
and
go on, I
Sorry.
just want to address the audience. I saw a hand go up. We will have time for Q&A from the audience. It will come
Okay.
up. So hold off on your questions. Remember them, write them down. Back to the panel. You wanted to
I
say
think,
something?
Rosa, I'm trying to come back to kind of addressing some of the considerations around the question you posed. And it's kind of transitioning, at this moment, as everyone has pointed out, SOPA and PIPA are kind of DOA from the standpoint of they are not law. I think what's interesting to me about ACTA is this conversation around the fact that as we seek to impose our copyright law on foreign websites and some of the points that have been discussed, we're not really having a discussion then about the rules, rights, and responsibilities of other countries. In certain instances right now, this was exemplified by Egypt and then Syria during the Arab Spring, the censorship of the internet by China. The internet is not monolithic. The internet is not the sole sovereign domain of the United States. And I think we have to have a thoughtful conversation about how we can coexist in the same way that we address trade and other issues with other countries, how this type of legislation that in the interest of, I respectfully maintain, treating copyright and intellectual property as more important than other considerations, that it does have unintended consequences that I don't really think that the law is exploring or taking into account. And it doesn't make the internet free and open and fair. I'm not being naive. There are problems that have to find a fix. This legislation is not doing that.
I just want to note that ACTA was a treaty, so it's not
not a law.
a U.S. law.
I do
It's not
understand.
actually all ACTA did. It's an international treaty, and it just required the states to bring the countries that have signed on to it to bring their copyright law into compliance with it if it already wasn't. But the concept of imposing U.S. copyright law, actually we tend to lag behind other states in other countries, states being capital S states.
Nation states.
Even in the late 90s when we had to pass certain laws to bring our copyright into compliance with various treaties, like the WIPO treaties that we signed on. So it's not really imposing our copyright law on other countries. It's enforcing U.S. copyrights in U.S. created content, but the copyright law is being enforced via international treaties with other nations that have comparable copyright protections, or like in the case of nations that don't have comparable protections, maybe we do try to get them to comply with ours via, you want something from us, you comply with our copyright law. If you want our trade goods, we want you to better protect intellectual property. Kind of approaches. But yeah, it's not. And that was an interesting conversation I had with my friend in Sweden just the other day when I was talking about doing this panel, saying, that I was going to do this panel, and I was asking her kind of a little bit about the views over there, and they said, the U.S. is trying to impose its copyright law on everyone else. Like, no, Sweden has actually in some ways a more robust copyright law than we have. So it's not our copyright law. These are comparable laws throughout many countries in the world. It's just.
I guess, Danielle,
Nat wants to say something. He
Yeah.
hasn't said
Well, why
anything.
is it when we bring our copyright laws into sync with other countries' copyright laws, we always seem to carve out the work for hire provision, which no other country has?
It's an interesting.
That says if you're employed by somebody, they own the copyright even if you create it. Or worse, if you sell something on which you have the copyright to somebody else, they can force you to sign over your copyright to them and say it was retroactively theirs all along. No other country has that in the world. We have it here. And anybody who's ever sold a script to a television network or a studio knows this.
Yeah,
Just saying.
No, but and it is a unique thing. We also, no other country has, the moral rights that France has, which gives authors, some control over their work, no matter whether they signed away all rights. Most famous case involved Ted Turner trying to colorize who was
Wizard
it?
of Oz?
No, it was.
It wasn't Citizen King.
Citizen
That was,
King.
but that was
Was it-
Wells's contract with RKO. It was something else.
Yeah, there was. I can't
Rules
think
of the
of what
Game
it
or Grand
was.
Illusion or something.
It was one of, it was, I am blanking on the parties to that lawsuit now. But they tried to, when, back in, I think it was the 90s, they were,
Casablanca?
I don't remember, an old black and white movie.
But it was something
that
based on a French work.
And-
That'll help.
Well, and it was shot in black and white as an artistic choice, not because of the technical. It's been a while since I read it. But
Just
the
Google it.
family sued in France because of the moral rights, which they have, which said, the author can control the depiction of their work, throughout the rest of the lifetime of the work, basically, which is a concept that's completely foreign here and pretty much in the rest of the world. So
Right.
every country has its quirks. I think work for hire is a very corporate, but corporations are people in the U.S. now.
I forgot. I'm sorry.
That's
Has anybody heard of an organization in Washington, a group of lawyers called the U.S. Copyright Group? You probably should have. Well, this one, it came to the forefront a couple of years ago with The Hurt Locker. The movie didn't generate the revenues that they thought it should at the box office. So this group, and they'll have several clients, will go out after people who have illegally downloaded the movie and send them dunning letters saying, if you pay us $1,500 or $2,500, we won't prosecute you. Of course, there were immense privacy concerns because they were asking ISPs to release everybody's browsing history. But this is one way, like it or not, of going after specific people who are the problem and not closing down entire domains.
And because this is a Burkle Center for International Relations event, how does that work in an international context? Do they go to Malaysia and ask the person in Malaysia for $1,500? Even if in some of these websites they have registries that aren't registered to anybody.
I guess you're just SOL.
If you can explain for the audience.
Not on tape.
Danielle?
I don't have the expertise in that as an ACLU person, so I defer to my colleagues from around the world.
Okay.
Well, I mean, therein is the problem. I mean, there is what jurisdiction do they have, and as when you start dealing with a lot of stuff, that kind of tactic, it becomes a cost-benefit analysis. Can you go after? Is it going to cost you, $100,000 to go after the guy in Malaysia who downloaded one copy of the Hurt Locker? I don't think you're going to find many companies doing that. There are a lot of jurisdictional issues in those kind of situations.
And I'm going to give the last word to Noam because we do have to go to the audience for their questions. So
The two challenges that I think are interesting, not necessarily being an economist to look at these individual instances of infringement, but this was true when the RIAA was going after grandmothers and teenagers, let alone that they established a methodology by which downloading 3 songs meant that they could sue you for $100,000. So I think that some things are fundamentally out of whack in terms of the implied economic harm and the consequences therein. But to answer your question in an international context, and again, I premise this perspective on the sole domain that I'm an individual who lives in a globally connected world, who works in an industry that does that as well, and I'm intellectually curious. For a long time, China was a particular area of concern when it came to infringement, and the sea change by which China is opening up its markets. There are more movie theaters, more American content is coming in through legally established protocols, means that there are, in fact, proven ways where we can change the conversation, where there is not the same sort of mechanisms to address the one download in Malaysia or everywhere else. If we stop acting like we can go around as the copyright police around the world and engage in the conversation in the manner in which we have, there are fixes. I'm not saying I know what they are, and I'm not saying they necessarily all would work, but I'm just tired of the one-sidedness of the conversation, which says owners of copyright are always right, and everyone else is always wrong, because it's not that black and white.
Okay, and with that, I see a lot of hands. We're going to go to the Q&A session, which is personally my favorite part, because I don't have to talk as much anymore. So you can go ahead first.
Okay, I'll address this to Danielle. how to make this into a question rather than a comment.
Yes, please.
You've lost the war. Why continue the battle would be the question. But looking at your industry, since the last 20, 25 years, your ancillary rights have exploded. There's no way you're going to change character, particularly not in this society. You've seen the educational system we have today. Give it up. Fix education first. But I guess what I'd like you to address is why don't you agree with perhaps, or maybe you do, with Noam that your industry could change the business model. Leave the INET alone. It's too valuable. Don't try to regulate it. Don't try to come up with laws that legislate information. Leave it alone. Develop new business models, which is essentially what he was saying, but not stepping in.
Well, I agree. I mean, again, personally, from my personal perspective, I agree and disagree with that concept. I mean, as we were discussing before, we've seen that changing business models has made a difference. And seeing how, we're still in the process of seeing how these business models shake out. And I also strongly agree that it does start with education, which is why I think it's very important that people understand that there are implications to what they're doing when it comes to downloading content. For instance, that there are revenue trickle downs, that people are being hurt by it, other than just that what they perceive as big business. I don't think necessarily just leaving the internet alone is the answer, because there are laws still need to be enforced, and the Wild West of the internet that we've seen, it's finally coming into a maturity as a platform. And I'm not saying we should be shutting down the internet because somebody is downloading. I mean, obviously the internet's there, the internet's ubiquitous, but I think the conversation needs to be had, and people need to understand that there are consequences to their action. What the proper solution is, what form of legislation it would take to regulate it without impeding the internet, needs to be worked out between stakeholders on both sides of the debate, between the industry. And it's not just the entertainment industry. When you look at what SOPA, for instance, did, and ACTA, it deals with counterfeit goods, and among the things that SOPA was intended to address is counterfeit pharmaceuticals. People can order drugs online, and the statistics, which I can't recall what they were, but when I read them, they were pretty staggering as to what percentage of internet purchased pharmaceuticals are counterfeit, and that's putting people's health and life in jeopardy. Life-saving medications that they think they're ordering may turn out to be placebos or something completely different, or they could be thinking they're ordering something innocuous that turns out to be toxic. So there was more to it than just copyright, which is what we're obviously talking about now. But you can't let that Wild West, you can't maintain the Wild West when there are so many different interests at stake. And in order for the internet to grow and mature, I think you do need some sort of regulation. I mean, our whole society is, it was the Wild West once, but we have laws in place now to regulate things as they grow and change. And I'm not sure I'm necessarily answering your question well, but I do think that it's a combination of both, changing business models and appropriate legislation. And legislation that protects people throughout the life cycle, both the life cycle and the distribution, production, all aspects of the entertainment process. The one thing that I had wanted to say before that I think is that I found very interesting in this whole debate, it was mentioned, Jennifer mentioned it in her introduction about not being really aware of this issue until the websites went black. I mean, how many people really thought about copyright infringement or online piracy in particular before a few months ago, before this discussion came up? Did anybody give it a... Okay, well, quite a few.
But interestingly enough, None of
The
the
students.
college students.
Yeah. So, yet you guys are here today to learn more about it. So whatever happened with these bills and wherever it went and wherever things go in the future, I think that those few weeks leading up to that day and the days surrounding it, helped open up an important awareness and dialogue. And, I think your questions are very valid in that ongoing dialogue is, what business models need to change, what is the proper form of regulating it, et cetera.
In the interest of fitting in as many questions as we can, you, sir, had your hand up a while ago. So,
perhaps this should be handled either through the federal courts, where these corporations that feel they've been ripped off appeal to the federal government to. We have the funds of a lot of the major offenders, for instance, China. If indeed China has run its entire government structure on stolen Microsoft Microsoft software that they did not pay royalties on, and it amounts to 100 billion, 200 billion, 300 billion, suddenly the trillion in US T-bills that they think we're going to pay them, the federal government could just say, guess what, we're not paying you 300 billion. We adjudicate that you've stolen 300 billion of our intellectual property and never paid for it and ran your whole government on it. And we're going to give it to our corporations, and they'll have to pay tax on it, and give it to our people. And when did stealing stop being stealing? That's my question. I mean, everybody is so intimate with their little keypad, but that same keypad could bring a knock at the door and agents coming to arrest you, and you mentioned child pornography, but you quickly left it, nobody picked up on it. But just as they can find every single person, just like they found Julian Assange, just like they probably are monitoring everybody now. And this December law that was just signed in, they could arrest people and hold them without warrant if they claim that you're an agent of Al Qaeda. And so they have the power to get every single offender and harass them. When you get a federal letter, a registered letter from the federal government telling you to appear at a certain date and time in court, or else a warrant will be issued for your arrest, and they're going to ask you to pay a $1,000 fine for downloading, this problem will go away. Now, that's the dream, maybe, of the property generators, intellectual property. But the point is, there are real consequences to this theft that's going on worldwide. And if people want American product, they should pay for it. And to say, because if they stop wanting American product, if they don't want to see our movies, then we're out of business in that industry. But right now they want it, and why should we give it away? They're not giving us their labor for free or their oil for free.
Your question.
So the question is there a chance that the federal government will take this up? Or will the State Department say, oh, no, don't do that, we don't like that. We don't want to start suing other governments who are impounding their U.S. assets.
Who wants to take a crack at this?
I don't think we do it overtly, but I think there's a lot of negotiation going on, give and take, in negotiations and treaty negotiations. Also, we should point out that it's not just the government which can go after infringers, but it's the individual people whose work has been infringed, and then you have to work through the court system, and God help you there. But that's really the problem with intellectual property, is nobody enforces it except the person whose intellectual property has been infringed upon. The government may establish penalties, but you got to start it yourself.
There are criminal penalties for copyright infringement, and some of the various legislation that's been proposed would potentially expand that for different things. There are some serious problems with enforcement, and Noam made a very good point early on. Why should copyright be such an important issue? Why should intellectual property be such an important issue when there are other concerns throughout the world? And I think for a government that is can't get its own house in order in many respects, I certainly don't think that, especially smaller scale infringement, they're not going to go knocking, the government's not going to go knocking on grandma's door for Johnny downloading songs, most likely. If Johnny was downloading child pornography, the government will be there. I think it's something that as a society we put a higher level of discomfort on, or reprehension in that context. So I think it's a matter of valuing government assets and where are they better placed. And I think from criminal enforcement standpoint, I don't see that happening. I do agree, though, that there's a lot that goes on. I think a lot of the opening of China that that Noam talked about came from both business negotiations as well as treaty negotiations, and a lot of behind-the-scenes negotiations. And it's a very slow process, but it's happening. I mean, there's been a lot of arm twisting to get them to enforce intellectual property.
We had a question in the back.
Oh, yeah. I have one thing also, though, as Noam was saying about opening China, I think if we make our content available for sale everywhere in the world, a lot less of it will be pirated. I have a friend who went to London to work on a film, and she'd been following the show Lost and discovered that they were 2 years behind over there. And so there was a big sort of conspiracy of how to get her episodes of Lost while she was there, and it all got streamed, and everybody involved works in this industry, including people who worked on the show. So that seems like a really much better solution to international piracy. Say, here, we'll make it available for you for sale so you don't have to steal it. But I want to ask the panel, Danielle made, I think, a really fascinating point about the way law students see copyright. And I had the same experience. I taught at Bolt and was kind of shocked by what the students see as the norm. And I actually was recently speaking with the general counsel for Warner Music, and they're getting devastated by some of the decisions at the federal appellate level because the clerks, everyone who's a clerk to a judge right now grew up after Napster, and they don't see copyright the way we do. And Warner Music went after a film, an independent film that put their song in the film, and the appellate court came back and said, no, it's fair use, they only used 30 seconds of it. And literally that sent shockwaves through the copyright protection community. Like, how could that possibly be fair use? And so I'm curious, are you guys seeing the law evolving in a way that is now, even with our own legal protections, taking it away because the generation of people who are making these decisions and who are voting on these decisions don't see a problem with sampling or taking someone else's work and incorporating it into your own?
Was that the John Lennon movie?
I can't remember the exact case, but
No.
I think, well, a couple of things. As a marketer, I think the concept of fair use has a lot of very liberal interpretations, but what I think is interesting, to your point, and one that I've specifically dealt with, is this idea that you can use someone else's content and your content that then you are going to monetize somehow, and that there's kind of convenient ways within the law that you believe allows you to do that, I think is very damaging. And I absolutely accept the premise that laws should be established that say there's a difference between fair use under the guise of the clip you're going to put on YouTube and other things that you're not necessarily profiting from. But the fact remains, and I think it's at the heart of your comment as I understand it, we have to have an honest conversation about people born before a certain year and after a certain year, where our fundamental values lie. And what I think is important in this conversation, which is very consistent with how Danielle began, if we move from this idea of the big bad monolithic corporation versus the individual, for me personally as a content creator, as a marketer, as someone who's trying to be a good citizen in this digital world, this technology that exists for us today democratizes the process in a way that things didn't in the past. So there was a time where if you wanted to be a filmmaker, there was that system that you had to be a part of. If you wanted to be a songwriter or a musician, there was that system you had to be a part of, et cetera, et cetera. That's simply no longer the case. I think a great recent example for those, particularly the students who are in the know, the comedian Louis C.K. Decided that he was going to do his comedy tour and film it, and he evaluated the business case for the opportunities. Here's the kind of deal if I do a television deal. Here's the kind of deal if I do a DVD deal. Alternately, if I do a digital deal where I take the risk and then I essentially put out a general entreaty to my audience that says, it's available, here's the PayPal link, I'm asking you to do this, and then, pardon my language, if you want to be an asshole and then put it on BitTorrent, whatever the hell that is, go ahead and do that. But he appealed to the better angels of people who ultimately said, he's not a corporation, he's a guy, he went out of pocket himself, and for his $250,000 investment within a very short period of time, he saw forgive me if I'm getting the specific numbers slightly off, a $1.5 million return. So he had a return on his investment. He paid a premium to the people who assisted him in it. And then he jokingly, he gave money to charity. And then he jokingly said, and then I will do something with my stomach. I'll either get liposuction or I'll eat a bunch of great food or something like that. And all I'm saying is there are opportunities that now exist so that, as Daniel points out, this assault, this perceived assault on the middle class and those artists, well, they can take that into their own hands now. And I think there are consistent examples that demonstrate the efficacy of doing so. Because remember, we still are a party to unions that negotiated deals, and that's a conversation for another day, that basically say the digital rights that I have as the writer of Dolphin Tale, when it first appears online for the first certain number of days, during which infringement is going on anyway, I don't get any benefit from that. How's that helping me? How is their attempt to try and establish those protections for me? They're not protecting me. So to your point, we have to have an honest conversation, and I think it's absolutely disingenuous for fair use to be a blanket excuse for clear copyright violation. But the flip side of that is, let's also not pretend that there isn't such a thing as fair use and that there isn't a way for individual artists to be successful. Just my opinion.
We haven't heard from John in a while, and he's been nodding his head the entire time. So,
Go ahead.
Okay.
Oh, okay. So I guess my question would be more directed at Professor Richardson because it's kind of more sociology based. But so I guess SOPA got a really bad rep amongst the public because of the blackouts and because of everything that was happening online. And so I was just thinking, what if the networks, the television channels, the cable networks, just retaliated by having everyone's favorite actor up on screen and telling people, call your congressman, vote for this. What would have been do you think it would have countered the internet blackouts? Because it's just funny to think about, is the mass population just kind of following along and not really actually caring about the whole SOPA issue? Or, would it have created a difference?
I propose something like that.
I don't know whether
actually.
that's going to happen. It's all speculative. There's a whole genre of what if kind of history. What if the South had machine guns in the Civil War? But what I'd rather take your comment, the fact that we're all interested and engaged in it, I think is a really interesting social movement. Now, it is true the bills are dead, but there is another Congress coming. Now, what would the next piece of legislation? That's how I would like to talk about it and ask you, what do you think should be the legislation? Or can you argue that, well, look, we've got cease and desist letters, we clearly have collaboration, mega uploads, whatever you think, is closed. The government, you could argue, already has enough authority. It doesn't need any more bills, any more laws to change what we're already doing. But I guess one of the things, I was talking with Kenny Cruz, who's a former student of mine. He's director of the Copyright Clearance Office at Columbia. And I was saying, Kenny, what's really interesting about this? And he said, it is the social movement. It's the fact that all of you are talking about this. Or what could we be doing at this time? Playing Angry Birds, or where are we now? So, to me, the question is then, how do we channel this? Where do we want this to go? What do you want to do with it? Because we clearly have a focus of attention. And, my favorite author. Whenever the people are well informed, they can be trusted with their own government. Whenever things go so far wrong as to attract their notice, they may be relied upon to set them to rights. 1789.
Thank you. Can I just also redirect that question? Because I remember that.
I know she wants to.
You had thought about that idea.
Yeah.
What gave you that idea? Kind of what happened to it?
Oh, it was just something I kind of mentioned in passing that, that was kind of my speculation is, what would happen, when the conversation came up about the websites going black. I talked to some of our people who, were more involved with things. I'm like, what would happen if we just decided as an industry, let's shut off everything on TV for a day and close all
Great
the
idea.
close all the movie theaters. But, you know, from a practical standpoint, what's going to happen? They're going to go download it. So, you know, it was, would that really work? I think it, you know, I saw an interesting comic strip the other day from, does anybody look at The Oatmeal? It's a, you know, it's got like some funny political cartoons.
Sometimes I do.
Yeah, and there was one, and this goes to your point about changing business models, you know, and Noam's point about wanting to be a good citizen, and this is why the approach of shutting things down wouldn't work. The little guy at his computer, he's like, I want to watch Game of Thrones. He's like, but I don't have, you know, HBO, I can't watch it on TV. He's like, let's see if it's on the HBO website. No. Okay, well, let's try iTunes. And it's like, shows it coming soon. Okay, Hulu? No. And he's got the little devil and little angel on his shoulders. And he's like, screw it. You know, downloading. You know, it was, you know, I think that's what would happen if entertainment went dark for a while, but...
Well, remember when Petrillo did it? No, you wouldn't remember. But Petrillo told the musicians, you can't play anymore.
That's right. Yeah.
Sounds familiar, but yeah, it was, you know...
That was over royalties of broadcast music.
Yeah.
Sure, the musicians union.
But yeah, it's an interesting question. You know, what do we need to do?
We have a question in the back, the laptop.
Yeah.
Yes.
The laptop has a question. I was wondering why this is becoming a tipping point now when there are other models of media that are using highly aggregated stolen content like Huffington Post and very arguably Google Books, which has over 20 million books scanned and does not pay royalties. And it does that on the basis of having contracts with university libraries. But is the enforcement answer going to be centered around making content-specific encryption and tracking of illegal behavior? Is it going to have to be based on how quickly technology is able to steal new content and recreate it? Based on how much faster that moves than the average human beings, like the average industry's ability to regulate it? Is it going to have to be industry by industry, books, movies, television, radio, music, stuff like that? Or is it going to have to be an umbrella process of just getting IP law prosecuted internationally?
Well, with the Google Books in particular, didn't Denny Chin, when he handed down his ruling, say that he really wished that Congress would deal with this? That he was sort of handing it back. I mean, you can make law in deciding law.
The courts do that a lot in copyright. There've been a number of cases where the courts have said, you know, this isn't us, Congress needs to change this.
Yeah.
And they've kind of punted, and we see what happens when Congress tries to change it. So, but
Yeah, I mean, sometimes I think I don't want Congress to deal with it because it'll be worse.
Yeah.
Well, yeah, maybe that's another conversation. Yeah, all the vested interest, how much money has to change hands to get.
Well, we've seen DRM doesn't work because within minutes of a new form of DRM being released, it's cracked. You know,
Right.
But yeah. I mean, I think a lot of it is going to. It really is just going to be, I think, really a combination of changing business models and finding an appropriate balance with legislation. And from a legislative approach, I think it's not going to be. I think the ISPs need to be involved. I think the copyright, the content industry needs to be involved, and they need to come up with something that works. I think YouTube is an interesting example of that. YouTube kind of forced
Fix it in post.
I'm fading. YouTube kind of forced the content industry into a model that it prescribed because it had gotten so rampant to some extent. I mean, there wasn't much leverage for the studios to negotiate at that point, but it really did. It took a lawsuit to get Google really paying attention, and Google did institute protections and ways to monetize content. I mean, I go find copyrighted content on YouTube all the time, but now there's a mechanism, if it's got copyrighted songs or whatever, there's, cut of that, whatever ad revenue is there is going to the recording company, or, cut of the the movie clip that's up there is going to the studios, and they've made it easier. So I think it is a combination of everything working together.
Maybe we should turn enforcement over to the people who track down college loans, because they can find anybody.
Yeah, they can.
Too true.
I thought what was really intriguing about your point is that, again, it comes back to that issue of perceived value, because I think the Huffington Post one is an interesting example. The publishing industry, the journalism industry, doesn't have the same lobbying power that others do, and it is a thoughtful and interesting conversation. I think, as is evidenced by Google, putting aside that now if you're using a track, there's a way that ad revenue is monetized. More importantly, there's now also, if it's a particular clip, there's a link that says go ahead and buy the movie here, and Google now provides renting of media. I can pull out my Android phone right now and we can stream media that is legally paid for. So it seems like the rubber has met the proverbial road in terms of, I think, what Danielle said, which is so important. Legislation in secret, or the perception of it being done secretly, leads to a lot of conspiracy theories. Let's have an honest conversation about how all these things are working, and allow all the stakeholders the chance to have conversation. Because at the end of the day, there are just better ways than stealing, and part of that is just not pretending like there's only one way of doing it. So.
And unless somebody ardently wants to add to that, that will be the last word. Is anybody? No?
All right. Well, thank you everyone again for coming. This about sums up the panel, and I encourage everyone to stay and mingle and talk to the panelists, and you still have, unless you're rushing off to dinner somewhere. But yeah, thank you so much for coming, and that's pretty much